Good afternoon, everyone. My name is Don Short, and I teach human rights law here at the law faculty. Welcome to our Distinguished Visitors Series. It's my pleasure this afternoon to introduce to you today our two speakers for this afternoon, Sarah Lugtig and David Langtry. Sarah is counsel at the Manitoba Human Rights Commission. She received her Bachelor of Social Work from the University of Manitoba and a combined Bachelor of Laws, Master of Social Work from McGill. Before she joined the Manitoba Human Rights Commission as counsel, Sarah held positions as policy analyst with Manitoba Justice, as Equality Rights Director of the Court Challenges Program, and as an assistant professor in social work at Memorial University in Newfoundland. She teaches, as you know, the Property Law Seminar here at the law faculty and has given lectures, judicial education, and professional development seminars on a wide range of human rights issues. David Langtry is Deputy Commissioner at the Canadian Human Rights Commission. He was appointed as a full-time commissioner in June 2006 and as Deputy Chief Commissioner in 2007. He's responsible for 3 areas of the Commission's work: case management, the National Aboriginal Initiative, and leading the Commission's international involvement on the Accreditation Subcommittee of the International Coordinating Committee of National Human Rights Institutions, a UN-supported body. David earned his LLB from the law faculty here at the University of Manitoba and was a partner in Wilder, and Langtry until 1990 when he joined the province to serve as Executive Director of the Multiculturalism Secretariat and subsequently as the Assistant Deputy Minister for Child and Family Services. Please join me in welcoming both of our distinguished visitors today.
Well, thank you very much, Don, for that introduction, and thank you, Deborah Parks, for inviting me to come to my alma mater to talk about the challenges and opportunities facing human rights commissions. Sarah and I have agreed that we're going to do a bit of a tag team approach to this, going back and forth, because we recognize that if either one of us did our entire presentation and did what we wanted to say, the other one would have no time left. So this is our trade-off, and I have put my watch down here, and I will be mindful of that because we do, of course, want to leave some time to hear from you and your comments, and we're particularly looking forward to that. The topic being challenges and opportunities. Because of time constraints, I'll look to one major challenge facing the Canadian Human Rights Commission and no doubt other commissions in Canada, as well as then one opportunity. But before I do so, I wanted to very briefly just describe what the Canadian Human Rights Commission is, because you might be like I was when I got a call in 2006 asking if I'd like an appointment to the Canadian Human Rights Commission. I said, sure, and then went downstairs and went on the internet to find out what it was. I knew the Manitoba Human Rights Commission, but frankly not the Canadian Commission. So just briefly then, the Canadian Human Rights Commission does have a mandate on all areas of federal jurisdiction. So it's all federal departments, agencies, crown corporations, as well as banks, airlines, railway, interprovincial transport, telecommunications, and that kind of thing. The Act prohibits discrimination by employers and service providers based on 11 very specific grounds, and if you don't fall within one of those grounds, a complaint cannot be brought to us. So it has to fit within one of those, which are race, national or ethnic origin, color, religion, age, sex, sexual orientation, marital status, family status, disability, and pardoned conviction. Our commission is probably best known for the receiving and investigation of complaints. We offer mediation, conciliation, and, of course, investigation. And less than 20% of the cases that come before us are sent to the Canadian Human Rights Tribunal for a hearing. The Canadian Human Rights Commission is a screening body. We do not determine if discrimination occurred. We can decide it did not occur and dismiss a case, or we cannot deal with it on jurisdictional or other grounds. But if we think that there is a reason for further inquiry, it gets sent to a very separate body, the Canadian Human Rights Tribunal, where the hearing is held. When we do participate in any tribunal or court cases, we represent the public interest and not the complainant or the respondent. And so we choose which cases we become involved in and are looking to ones that are really dealing with systemic discrimination or need to settle a major point of law, seek clarification to give us future guidance in how we should interpret the cases coming before us. We also have a promotion and protection broader than, of course, handling the complaints, and we engage in research, identifying emerging human rights issues, and developing policies to address them. We work with employers and service providers to help them develop best practices and avoid complaints before they happen. So the major challenge that I wanted to talk about, and it's always interesting when one works in Ottawa, as I do, you think that everybody across the country is listening to the same thing that we're hearing day in and day out. That may not be the case, but the one that I'm talking about is really the human rights commissions and tribunals across the country have been subject to a great deal of criticism in the media stemming from a complaint that was brought against Maclean's, actually Rogers Communications, the owner of Maclean's, on hate provisions. The public debate about freedom of expression versus right of equality and dignity highlighted a huge challenge that all of us face at the federal and provincial levels in ensuring that the public knows what the human rights system is, the work we do, and the work that still needs to be done. Briefly, the Maclean's case, or Rogers Communication, was brought in 2007. It was filed by the Canadian Islamic Congress at the Canadian Human Rights Commission, the Ontario Human Rights Commission, and the British Columbia Tribunal. And it alleged that excerpts that had been online and in the printed edition of Maclean's, excerpts from a book by Mark Steyn, America Alone, The End of the World as We Know It, had exposed members of the Muslim community to hatred and contempt pursuant to Section 13 of our Act, which is hate on the Internet provisions. The issue in the case was whether the excerpts were so extreme as to fall within the narrow definition of what constitutes hate messages as had been set out by the Supreme Court of Canada in a 1990 decision. In the end, all three of the jurisdictions dismissed the case, BC and ourselves on the merit, and Ontario on the basis that they didn't have jurisdiction. But before our decisions were ever made, tribunals and commissions experienced huge protest, commentators saying that mainstream media should not be subject to the hate provisions and that it was inconsistent with the freedom of expression that they're guaranteed. This led to the public debate discrediting commission's processes, the professionalism and our staff, and many facts were distorted, and much of what it was written about was frankly inaccurate. The Commission has always welcomed the public debate and discourse on this and every other issue as long as it's an informed debate. Really in this one, the decision we made was the excerpts did not constitute hate, and that's why we dismissed it. But that doesn't mean that we had the right to not even entertain the case in the first place and so on. Just to conclude this opening part, kind of a follow-up and fallout from the public debate around Section 13, we, the Canadian Human Rights Commission, commissioned Professor Richard Moon, a law professor, constitutional law expert. He did a report on Section 13. We did a special report to Parliament following the Professor Moon, and certainly available if any of you want to see it when we talked about Section 13. The Parliamentary Standing Committee on Justice and Human Rights undertook a review of Section 13, and we appeared as a witness at that. But I just wanted to mention, because for those of you who are interested in the debate, you might be interested in knowing that in December of 2009, the Women's Legal Education and Action Fund filed a brief with the Parliamentary Standing Committee on Justice and Human Rights. And in January of this year, the Canadian Bar Association also filed a submission. Both of them review Section 13 and the need for Section 13, even though there is criminal code penalties. And as I say, any of you who are interested, I would commend those to your reading. And with that, I'll turn it over to Sarah for her first segment.
I guess I'm supposed to go tag or something, right, if we're a tag team? Thanks, David. So thank you, David, and thank you also to Professor Parks, Deborah, and the committee for inviting us to be here today. And thank you to all of you for being here. I know it's one of those weeks where you're looking forward to a holiday or maybe lots of work next week, and it's really nice to have you all here. And to know that we have people in the law faculty who are very interested in what commissions are doing, and it feels supportive to us just for you to want to be here and to be talking about these issues. So I'm just going to start by responding a bit about the media concerns. And a lot of what you said, David, rings very true for us also at the Manitoba Human Rights Commission. Those of us who work at the Commission and who are involved in the Commission have become increasingly concerned about how the media has portrayed the work of not just our commission at times, but those across the country and other human rights institutions, and what the impact may be. And as David said, this is not at all to say that we should not be evaluating and examining our government or public institutions. It's a personal value of mine that I think it's extremely important to hold government to account. The media can play an extremely valuable role in doing so. So I don't think we should ever say that we don't want people talking about this. We don't want the media talking about human rights and reporting on human rights. But as David has mentioned, there seem to be limits on the media's either ability or willingness or impetus to ensure that all the information gets out there that needs to get out there for us to really have a useful discussion. And the result, for me anyway, is that a couple of often key questions don't seem to be asked, and then they don't seem to be answered. And it, even for myself as a reader, I'll be looking at or reading an article, and I have these big questions in my mind, and I'm kind of wondering, why aren't they asked, why aren't they answered? And I personally can't make up my mind. And it's not just about human rights issues that this occurs, but it seems to be part of the issue here. So I thought I would just raise a couple questions and get us thinking a bit about what the answers might be. So on these types of cases that have been in the media lately, one question I have, because it's really coming from this, concerns about freedom of expression, which are valid concerns and an important thing to be debating in our society. How big a problem is it? How many human rights complaints actually address hate speech? And if I was answering in Manitoba, I would say none. We don't even have a provision that prohibits hate speech in Manitoba, and there are many other jurisdictions that do not. And in those jurisdictions that do, the complaints on that basis make up a very, very small percentage of the work that the Commission does. Manitoba does have a discriminatory signs and statements provision, and that basically prohibits publicizing statements, signs, and so on that are attempting to incite discriminatory behavior or actually discriminate. And luckily, we don't see that many examples of this older sort of form of discrimination that there were many of before we had human rights commissions and human rights protections. But one of the reasons we have these provisions is that it wasn't uncommon at all, not that many years ago, to actually have blatant signs restricting access of certain groups of people to various public facilities, services, and so on. So we do have that provision, and it can raise similar concerns about freedom of expression because obviously it's governing expression in the sense of what it's restricting. However, it's important to note that it only restricts such expression if it advocates or causes or gives rise to discrimination with respect to one of the activities that the code covers, and there's no bona fide and reasonable cause for the discrimination. So there are inherent limits on the provision, and it's quite I won't get into the law on it, but there's quite a high threshold to prove that you have violated that provision, and there has to be quite a strong nexus to actual discriminatory behavior. So, and that's due to constitutional interpretive principles, as is the case with the hate speech ones. So I went and looked at our last 3 annual reports to find out what the stats are. And how many, if we looked at the last 3 years, who wants to guess how many complaints we had based on that? Yes, Karen. No. You're very close, though. Not 2? No, you're too high. 1 in the last 3 years, that was and it was dismissed. And I'm not going to ask you to guess how many complaints we actually dealt with in that period of time. We dealt with over 1,000 complaints in the sense of processed them to completion. And of those 1,000 complaints, they addressed all the myriad of grounds and areas that the code covers. Close to half of them resulted in a mediated settlement or were referred for adjudication. And potentially also often there's a negotiated settlement at that stage. And then another half, a little bit more than half, would have been dismissed or withdrawn. So the person decided not to proceed with it. So that one complaint made up 0.1% over the last 3 years of the issues that the Manitoba Human Rights Commission deals with. So when I say how big a problem is it in Manitoba, one answer might be it's not that big of a problem. And also, complaints are not the only thing that Manitoba's Human Rights Commission deals with. We have a broad mandate to educate about equality and to promote equality in Manitoba. And again, I was looking at the statistics in the annual report. And in those last 3 years, we spoke directly to, through workshops or outreach, and this is not the only thing that we do, about 8,000 people, 8,000 Manitobans, about their human rights, their obligations, and their rights under the code. And that's with a very small budget. We receive $14,000 annually to educate all of Manitoba about their human rights and their obligations. So this brings me to my next question, actually, sort of the one that comes to mind for me when I hear these reports, and this is what brings it to mind is the money aspect. I guess when I read a number of these reports, I wonder why no one is questioning some of the factual claims that are being made about the problems that people have experienced with respect to the processing of these complaints. And one I particularly, anyone who knows me has probably heard me talk about this before, but there's been one respondent in Alberta who's reportedly said that defending his complaint until it was dismissed by the Commission cost him $100,000 in legal fees. And he also estimates that it cost the Commission in question $500,000 as there were 15 staff engaged full-time to deal with this hate speech complaint. And this was about, I won't get into the details, but it was about a publication and whether or not it contributed the anti-hate provision in Alberta's legislation. I see those figures and I think, gosh, is that possible? And I find myself Googling, so I start Googling, and I have to say, I just saw these figures in an article by a journalist. They were cited again by a journalist who I respect quite a bit. I don't always agree with him, but he just floated these numbers out there as if they were fact and didn't question them at all. So I looked up Alberta's stats, and for the year in question, this would have represented 8% of their budget to deal with this one complaint. There aren't really any facts in dispute, right? The thing is published. Does it meet or does it not meet the legal test? And at that same time, Alberta dealt with their remaining 1,000-plus complaints, and they actually claim they did so more efficiently than the year before, and that the public was more pleased with their performance than they had been the year before. So the lawyer in me says this just doesn't add up. How could this one complaint be taking all of this time and requiring all of this cost and so on? And I'm not saying it did or it didn't. I'm just wondering why nobody asks the question. And if anyone has read any more information responding to these types of claims, I'd be very interested to hear about it. I'm not saying it isn't out there. I just haven't noticed it. And another problem that you may not be aware of, and I became aware of in my role at the Human Rights Commission, government agencies are quite restricted in what they can say to the media when things are said about how they dealt with a particular matter, and we're governed by privacy legislation. any human rights complaint will have another party involved, and they have rights under legislation not to have their personal information shared with the media. So there's quite a lot of restriction on what we can say. And so it's not just that the government official doesn't want to say anything. I bet sometimes they really would like to say something when they say no comment, but often it's very difficult for them to say anything specific. And I also learned that apparently the government can't sue anybody for defamation. Did you know that? You can't defame the government. I didn't know that. So there's another restriction on people, when they're out there in the public domain saying things about others. They can say things about government with less worry about what the consequences might be. So I'm not saying we can necessarily avoid any of this, and it's not a good thing, but I think it then means we really are depending on journalists to ferret out what the inconsistencies are and to check facts and so on. And my impression is this is not always the case, certainly not sufficiently with respect to this debate. And a question I have for you is, do you agree? And why is it? And is it only human rights issues? Is this a particular problem with respect to human rights commissions and issues, or is it generally an issue with the media, and is there anything we can do about it? It's trite to say don't believe everything you read, but it's actually become extremely important on this issue, because the undeniable result has been a repeated and very well publicized call to eliminate our human rights institutions in the country. And this is very troubling when the impetus is coming from an issue that makes up a very small part of what we do, and if the information that the public is receiving is one-sided. It's particularly concerning because we do have I'm not saying the freedom of expression issues aren't important, but we do have really pressing issues of systemic discrimination that we need to be dealing with and take a lot of resources, and these other issues do take our attention away from that. So with that, thank you for listening to my bit of a rant on this issue. I'll turn it over to David to talk about some of those challenges.
Well, thank you again. Sarah, when you had mentioned that there is case law that says that governments cannot be defamed, I'm sure there's a line in there somewhere, something about to be defamatory, there must be a loss of reputation. In any event, I'm sure there's a line there somewhere. I wanted to turn to one of the opportunities, and as Don had mentioned at the outset, one of my portfolios that I'm responsible for is the National Aboriginal Initiative, the national office of which is actually here in Winnipeg, so I do get a chance to work out of my Winnipeg office from time to time. The reason we have a National Aboriginal Initiative office here is that in 1977, when the Canadian Human Rights Act was passed, there was what was then described as a very temporary measure or section inserted in the Act, Section 67, the last section of the Act, which provided that nothing in the Canadian Human Rights Act affected any provision of the Indian Act or any provision made under or pursuant to the Act. As I say, it was intended as a temporary measure 33 years ago, and in part that was because it was recognized that the Indian Act in and of itself is discriminatory, and particularly in the treatment of women who married out, so to speak, who lost their Indian status, whereas a Indian man who married out did not lose his status. So the intention was that they would fix this quickly, and then they would have repeal Section 67, and we would have full jurisdiction for matters done under the Indian Act, as well as being able to take challenges against the Indian Act. That occurred in 2008 when it finally got passed, and this followed two submissions, special reports to Parliament from the Canadian Human Rights Commission, A Matter of Rights and Still a Matter of Rights, amongst other panelists and so on, and private members' bills over the years. But this was very exciting news for the Canadian Human Rights Commission, and I believe First Nations communities across the country, because they finally have access, after over 30 years of being denied access to the Commission, to those fundamental human rights protections that were enjoyed by all other Canadians. Part of the legislation C-21 that passed to repeal Section 67 had a provision, and I apologize for the length of it, but the reason I'm raising it is it was a provision that was cobbled together by opposition parties and agreed to by the government. So it is not one that had the legislative development in advance, so one would know what parliamentary intention was and so on and so forth. And what it provided, it states, is in relation to a complaint made under the Canadian Human Rights Act against a First Nation government, including a band council, tribal council, or governing authority operating or administrating programs and services under the Indian Act, this act shall be interpreted and applied in a manner that gives due regard to First Nations legal traditions and customary laws, particularly the balancing of individual rights and interests against collective rights and interests to the extent that they are consistent with the principle of gender equality. So, the Act is passed, and there is a 3-year transition as against First Nations government. In June 2008, when it received royal assent, it was immediately applicable to the federal government, but there's a 3-year transition for complaints against First Nations government, and that's when the interpretive clause will take effect. So there are a number of issues that arise from this interpretive provision, and to the extent to which, and only when a room full of lawyers, as well as our meeting with First Nations people and their representative organizations, did many of the issues come up. And as you really read it and where commas are and so on and so forth, that it really does create issues. We at the Commission have therefore, since we're the ones who have to now interpret the Act and begin to receive complaints in June of next year, we commissioned a fairly major research project, the first part of which is balancing individual and collective rights. We will be publishing that research probably within the week. It was a long time in the making, and it's fairly comprehensive. And we are in the process now of engaging researchers to do research on gender-based analysis. And so there will be a series of research to help us interpret the Act. But as I say, it's still nonetheless, and it's the first time that individual collective rights and First Nations have been recognized in federal legislation. So there's many positive aspects about the bill, not the least of which, of course, is, again, that Section 67 has been repealed. What this brings to us, obviously, is tremendous opportunities to now be reaching out to First Nations communities. The fact of the matter is, of course, that since they've been denied any access for over 30 years, they don't know us, as much as many of you probably don't know us, even more so, because there's been really no complaints that would lie to us until now. We also need to learn from First Nations communities as to what are the legal traditions and customary laws, which are defined in two different ways. One is pre-contact, pre-colonialization, and others that have developed and a customary law can be today, and so on and so forth. So we need much to learn, as well as our legislation emphasizes alternate dispute mechanisms. And of course, many First Nations have told us that they have such mechanisms, but they're not in the Western civilization context, and so they've certainly urged us to be mindful of that and to be open to learning of what their methods might be, so that when I receive a request to not deal with a case, to allow an internal redress mechanism to take place, that we would give due regard to their legal traditions and their own internal mechanisms. What we have done is, over the last year through the National Aboriginal Initiative, is we have been meeting with national organizations, regional organizations, accepting any invitation that we might have. In 2009, we accepted over 25 invitations to provide information workshops by regional Aboriginal organizations. We do have a steering committee made up of the Assembly of First Nations, Native Women's Advisory Council, and Congress of Aboriginal Peoples, being the three national organizations most affected by the repeal of Section 67, because it is First Nations who are affected by it, not necessarily the Inuit and Métis, because it's the Indian Act application and the status under the Indian Act that is affected. In collaboration with the Native Women's Association of Canada, we're developing a plain language guide on the Act, specifically for Aboriginal people, and also developing a First Nations a guide for First Nations managers to help them apply the Act in their workplace. As I say, the Act already applies to the federal government, and we have already started to receive complaints. Sarah rightfully had noted the confidentiality. I was able to talk about the McLean's case because it's been broadly advertised, but otherwise until and unless we send a case to tribunal or an application to federal court is brought, we're not able to talk about it. But one that, a fairly major case that we have sent to tribunal is one that was brought by the First Nations Child and Family Caring Society together with the Assembly of First Nations against Indian Affairs and Indian and Northern Affairs Canada, which alleges that the federal per capita funding for First Nations children is discriminatory on the basis of race because it is significantly less than provincial funding for non-First Nations children. We referred this case to tribunal, and I should say there's a number of very major systemic discrimination cases that we have sent on to tribunal. The federal government, because of many reasons, has been taking issue with and challenged jurisdiction on many of these complaints, one of which, for example, is that under our Act it needs to be either an employer or service provider, and INAC is taking the position that the funding of child welfare, they don't deliver the services, they simply fund the services. So they're suggesting we don't even have jurisdiction to consider the case because it is not the provider of service. I can tell you in another case where a similar argument was raised, not in this one. The complainant, in rebuttal to the position that Indian Affairs was not a service provider, they did respond saying actually they had to agree that Indian Affairs does not provide a service to the Indian people. They provide a disservice. So in any event, I get to read some good issues. So those are a couple of the significant cases, or one rather in particular, and certainly we at the Commission are looking forward in June 2011 when the rest of the Act is in place. This will be no doubt our main focus for several years to come. So back to Sarah.
Actually, thanks, David. The issue that David ended with is one that I also want to speak to because it has become quite a focus of attention at the Manitoba Human Rights Commission. And this issue is the impact that jurisdictional disputes between provincial and federal governments can have on First Nations communities, and particularly people with disabilities is the one that we're most looking at right now. And we have had community organizations come to us talking about really quite deplorable conditions that people with disabilities living in some First Nations communities in Manitoba are dealing with. And I have to say, if you saw some of the footage that we've seen, I'm sure you would be shocked at the lack of access that some people have. And the argument, again, similar to the Child and Family Services case, is this is discriminatory. Why if I live in a First Nations community and I'm a First Nations member, do I have so much less access to the services and supports that I need as a person with a disability, either a child or an adult? And if I were to just move, a few miles to another community that's served and under the jurisdiction of the provincial government, I have supported living, I have home care, et cetera, et cetera. And I think you probably remember this issue hit the news with respect to the death of a young boy from a First Nations community in northern Manitoba, Jordan River Anderson. And this related to, this is a little boy who had a number of disabilities, and he spent a lot of his young life in hospital. And he was ready to go home to his community and his family. And he died in hospital while the province and the federal government were fighting over who would pay home care for him. And the tragedy there has led to some movement at a policy level. And you've maybe heard talk of Jordan's Principle, this sort of a policy notion that requires the two levels of government to at least agree that someone will provide the service needed, and then they'll sort out the jurisdictional debate later. I think they call it like a child first principle. And however, many would argue that Jordan's Principle, to the degree that it's being applied, is quite narrow in scope and is focused on health needs and on children's needs. And we are hearing anyway that it's a much larger problem than that. And there is certainly at least a view that jurisdictional disputes in terms of who is responsible for providing services for persons with disabilities living in reserve or for First Nations communities is part of the problem. And so that's the issue that's come to the attention of the Manitoba Commission. And it's not an easy one to deal with when you are a public body that is also bound by jurisdictional considerations. We can't deal with things that are outside our provincial jurisdiction, and neither can the Canadian Commission. And right now, the issues around constitutional division of powers and jurisdiction and authority regarding, Indians and lands reserved for Indians under the Constitution Act, it's really quite an open question right now, particularly when you're talking about services that a province normally provides. There's a case before the Supreme Court of Canada right now about whether it's the provincial legislature or federal parliament has jurisdiction over to regulate employment in First Nations child and family services, for example. We, for a very long time, always thought it would definitely be a federal issue, and then we've had rulings saying, no, that's a provincial issue. And this just adds to the complexity for anyone who's trying to have their issues dealt with if this jurisdictional question comes up. So say someone did walk in our door wanting to file a complaint. Where do they file the complaint? Is it Manitoba or Canada? Who do they file it against? Manitoba or Canada? What happens if they file a complaint in both commissions? What do we do about that? And so luckily, I think we've had a lot of dialogue and collaboration with the Canadian Commission, with the Treaty Commissioner, who happens to be in our same building, which is very good. So I think this actually arose from a discussion in the elevator. And First Nations governments and community organizations that work with people with First Nations people with disabilities, and it's at least at the beginning of a dialogue about what can be done at a systemic level to address this and to make sure that there is a forum, if people want to litigate the issue, that there is somewhere that it can be brought up, and that to the degree possible, jurisdictional disputes will not then become a problem in terms of trying to address it. On a related note, another significant challenge and opportunity for both commissions, I think, right now, is to deal with systemic issues. And this is the idea that you might have many, many complaints coming to you where an individual has experienced discrimination, but it's because of a broader systemic pattern or practice in their community or in their society or even with a particular employer. And how do we address that? And the Manitoba Commission has actually been fairly successfully dealing with some systemic issues, and we're learning as we go. And it's been very helpful to us that community advocacy organizations are coming to us. The Public Interest Law Centre at Legal Aid Manitoba has supported a number of community organizations who want to raise and deal with systemic issues. And so far, I don't think we've actually litigated one before an adjudicator in the sense of actually having a hearing on one, but we have had a number of systemic settlements, both through the mediation process in our commission and also negotiating settlements of complaints at the adjudication level. And just some examples are pedestrian signals in the city that are accessible to persons with visual and other disabilities. If you've noticed more of those around, that's partly because there's a human rights complaint that resulted in a settlement. There have been policy changes and program changes in provincial women's correctional facilities to address cultural and religious and disability-related needs, and Deborah Parks is very involved in that settlement, and I have to say, informally, has been greatly credited with a lot of the success of that process, so thank you, Deborah. And as a result of that as well, every new corrections official gets human rights training, so that's keeping one of our officers very busy, but we think that's very important. We've seen increased income assistance for persons with mental disabilities who live with their families. We've just recently seen better financial support for family members who provide home care for their family members. And we've also seen more fair and equitable rules in place and supports for internationally trained professionals in various contexts. The one that's gotten the most attention has been for internationally trained medical graduates, but there have been others as well. The other thing you may want to know is that Manitoba and Canada are working with their counterparts across the country to develop a settlement database that would actually record the systemic settlements, the key ones that have been made, and have them become available, probably at first internally. We'll have to see how it goes, but eventually potentially available to the academic community, to the public, to see what actually is happening when these systemic issues are settled so that they can also serve as a practical precedent if they're not a legal precedent. And the Manitoba Commission also engages in other proactive measures in addition to settlements, such as our, I have to get this right, Racialized Communities and Policing Project, where we're working with the University of Winnipeg to address issues the community has raised about bias and policing. So while we are facing significant challenges, I do think that we are seeing in them opportunities to do things better and to improve, and we do really want to know how to do that. It's not that we seem to not like criticism in the media. That may be true to some degree, but we really see commissions as owned by the people and fundamental institutions in our society and in our community, and the more that we can work together to address these issues in a more effective way, I think that the better we all are. So I thank you very much for your attention, and I think we've got time for questions, and we're really curious to know what you all think about these issues. Thanks. That's fine. So the question was, what do we say to the claim that is at least partly legitimate or partly understandable that a complaint like the ones regarding the Western Standard or the newspaper articles and ads and the Maclean's article, that they do put a respondent to cost of some level at any point and seem to be taking a long time to deal with. And what do we do about that? Now, I have to say I'm actually not in a position to comment on those because I don't know what happened internally in the process. Some questions I have are, especially with perhaps some more than others, what role did the respondent in that case play in the time that it took? And what were they like to deal with? It's only a question, but that question never gets, no, but it doesn't get asked, and it's very difficult for us to answer that question if we're ever put to that. Because every commission, as far as I know, has an ability of a sort of a summary dismissal if something's frivolous or vexatious or clearly does not contravene the code. So I would agree with the question, and I have the same question to some degree, but I think there may be some other things going on there, and again, it just shows how difficult it is to really understand how to deal with this.
Thanks, Sarah, and indeed, good question. And certainly, if you were to read our special report to Parliament, you will see that we've addressed both the issues of cost as well as the length of time these proceedings take. I should say that probably prior to the Rogers case, the McLean's case coming forward, we dealt with every hate on the internet case the same as we dealt with other complaints, which is there's intake, there needs to be investigation, the reports need to be disclosed, there's cross-disclosure, each side has an opportunity, there's a mediation, a conciliation if the parties are willing, and so on, and then it comes up for a decision, and that can sometimes be time-consuming. We recognize that that in the case, in some of these cases, the facts really are not in dispute, so the issue is only does this meet the narrow definition of hate? There's no dispute over who published it, that it's in Canada, and the complainant is saying that in their view it's hate. So as part of our special report, we had made one of our recommendations was that Section 41, which is the one that we can decide not to deal with, be amended to include a provision that allows the early dismissal of Section 13 complaints when messages do not meet the narrow definition of hatred or contempt. In our view, that exists already, and I will be using some sections of 41, but we have asked for clear definition. On the issue of costs, and that, of course, would be a longer discussion or debate, no doubt, but administrative tribunals, of course, there's no requirement for counsel to be there, notwithstanding many do have counsel, and it's really an access to justice issue, why legal costs are not awarded and so on. But having said that, our special report as well, which is supported by the Canadian Bar Association submission as well, is that it is recommended that the Canadian Human Rights Act be amended to allow for an award of costs in exceptional circumstances where the tribunal finds that a party has abused the tribunal process. So it's in the more extreme if it's really felt that they're bringing it, frivolous, vexatious, that hasn't been screened out earlier on. But otherwise, we would like to say that we process our complaints fairly quickly. Our average age of cases, our annual report will be coming out in March, and the average age of cases, which is somewhat misleading, and I can explain it if time permitted, the average age of cases at the Canadian Human Rights Commission is 7.8 months. So used to be 25 months.
Thanks. So the question was, we have all of certain individuals particularly who have been really critical in the media of human rights commissions, and what are the commissions doing in response, and how can those of you who in the public who want to defend commissions, what can you do? Is that fair summary? I won't deal with Richard Warman question. I'll let David, because it's more within their jurisdiction. And I'll give a shorter answer. I think probably David's been more involved in some of the things that are being done. One thing that you can do, however, and someone in this room did so recently, I think it was Roland, the Manitoba Commission came under fire around a certain issue, and this was in the Winnipeg Free Press, I think, and also there was interest as well from the law faculty, and writing letters to the editor. Yeah, they didn't publish Deborah's, that's right, but I know they published Roland's, and apparently it was gone before, it was out off of his email before he'd even finished reading the article in question, something like that. But that really makes a difference. And it makes a difference to us who work there and doing the work. It makes a difference to the people who care about these issues, because otherwise you have this view that nobody cares about human rights, and that's just not true. It's not true, but because of the way the media portrays things sometimes, you get that impression. So that's my one suggestion for you. And also, many human rights academics and lawyers will make themselves available to speak to the media about these issues, which also is very, very important. And maybe some of the rest of you have ideas about other things that you could do. So, thanks.
Yes, thank you. And it could be a long response, but it won't be because I see it's 3 minutes too. So, and certainly when this first came up, we would say at the Commission when it first came to our attention that Maclean's was now a respondent, because we can't be told until it comes before us as to what is in the hopper, so to speak. Didn't realize kind of where it would go, but as soon as it came up and we realized what we had before us, we embarked on saying what would our communication strategy be. And as all of you would be well aware, it's very difficult when mainstream media, when you're taking them on, if you will, because they have the ink barrels. So we had actually gone on an individual reporter by reporter to try and set the record straight, if you will, but the misinformation kept getting repeated so often that it became truth, and it wouldn't matter how much we would say that that's difficult. It's very difficult when you're under attack to be the reputation manager, and they always say third-party endorsements are the best. So we embarked on, we did have an outreach strategy. We met with every member of Parliament who were on the various committees before appearing before them. I've appeared before committees and that, so that they heard our message, so we weren't coming in without. We as well spoke with all of our counterparts in the provincial human rights commissions and the like to get the message out. Our special report to Parliament and the Moon report, which was an independent report that we commissioned to do that, and so on. And what happened actually probably last fall, our appearance before the Parliamentary Standing Committee on Justice and Human Rights, where we had a first opportunity to be there and put on the record and challenged the misinformation that had been put on the record, in our opinion, by Messrs. Stein and Levant the 2 weeks before our appearance, and we provided all of the documentary evidence and so on, and the tide really shifted. But more importantly, some of the outreach that we did and urging organizations that supported commissions, urged them to speak out because they would be heard. And for example, when I referenced the Canadian Bar Association submission, which of course is 37,000 lawyers or whatever, so it's fairly strong, and this was just filed in January. But one section of that is of greater concern to the CBA is the fact that the debate surrounding the expediency of Section 13 has become the proxy for an open assault on the very existence of an administrative framework to protect human rights in this country. Critics have decried human rights proceedings as kangaroo courts, which provide only drive-through justice, and etc. And they go on to say, we reject attacks of this kind and reiterate forcefully our support for the continued importance of the work undertaken by them, and so on. So those things get heard rather than me standing up saying, I want my job.
Well, I know I think I saw some more hands, and we'd love to have a little bit more time, but I know people have classes to get to and other commitments. So I will take this opportunity to just, on behalf of the Faculty of Law, thank both of you for such an interesting presentation. There's obviously lots to think about, and lots, I think, to be done by those of us who do care very much about our human rights institutions and protections of human rights in this country. And one little plug I will say is that the Faculty of Law, you may know, human rights has been identified as one of our strategic areas of focus moving forward. We have, I think, I'll say, a great deal of capacity here in terms of expertise, some of the folks in this room as well as those who aren't able to be here on human rights issues. And the university has also taken a lead in launching a new center. Like it's a planning initiative right now at the stage, but it's a Center for Human Rights Research here at the University of Manitoba. And Karen Busby has been instrumental and is the sort of, I guess, interim director of that initiative, and has been doing an incredible amount of work networking across the university and community on some of these issues. So I think there's lots of room for students to be involved in these initiatives. So please talk to any of us about that. But again, just join me in thanking Sarah and David for such interesting presentations.